Good morning and welcome to the fourth meeting of the Equalities and Human Rights Committee. We have one item on our agenda today, and that is Stage 2 consideration of the United Nations Convention on the Rights of the Child Incorporation Scotland Bill. Joining the committee today are Rachel Hamilton and the Minister for Children and Young People, Marie Todd, and her officials. You're all very welcome this morning. It will work well if we take it slow and steady. When I call you to speak, please pause before speaking to allow your microphone to be switched on. Members should have a copy of the bill as introduced, the marshalled list of amendments which sets out the amendments in the order in which they'll be disposed of, and the groupings. There will be one debate on each group of amendments. I will call the member who lodged the first amendment in that group, speak to and move that amendment, and to speak to all other amendments in the group. I remind members who have not lodged amendments in the group but who wish to speak, you should request to speak by typing R in the Blue Jeans chat function. Please do this once I've called the relevant group, and please only speak when I call your name. I would ask anyone doing so to make sure their contributions are relevant to the amendment or amendments being debated. Standing orders give any Scottish Minister a right to speak on any amendment. I will therefore invite the Minister to contribute to the debate just before I move to the winding up speech. The debate on the group will be concluded by me inviting the member who moved the first amendment in the group to wind up. Following debate on each group, I will check whether the member who moved the first amendment in the group wishes to press it to a vote or withdraw it. If they wish to press ahead, I will put the question on that amendment. If a member wishes to withdraw their amendment after it's been moved, they must seek the committee's agreement to do so. If any committee member objects, the committee immediately moves to the vote on the amendment. If any member does not want to move their amendment when called, they should say not moved. Please note that any other MSP may move such an amendment. If no one moves the amendment, I will immediately call the next amendment on the marshalled list. Excuse me. Only committee members are eligible to vote. When I put the question on an amendment, any committee member who disagrees should type N in the chat function. The vote will be conducted by roll call in the following order: Alex Cole-Hamilton, Mary Fee, Joe Fitzpatrick, Alison Harris, Gillian Martin, Alexander Stewart, with my vote given last. When called, each committee member should respond with either yes, no, or abstain. There will be a brief pause while the clerks confirm the vote, which I will then read out. Should you consider that your vote has been incorrectly recorded, then please let me know as soon as possible. I'll pause to provide time for this. In the unlikely event that time is against us this morning and we do not manage to complete our consideration of the amendments by 1:30, we will continue consideration of the bill at our next meeting. If we lose connection to any member or the Minister, suspend the meeting until we reconnect. Depending on how long proceedings take, I may suspend for a 5-minute comfort break at a suitable point. We'll now begin Stage 2 proceedings. The question is that Section 1, Schedule, and Section 2 be agreed to. Are we all agreed? We are all agreed. I call Amendment 6 in the name of Alexander Stewart in a group on its own. Alexander Stewart to move and speak to Amendment 6, please. Alexander.
Good morning, Convener. I move Amendment 6. The effect of this amendment ensures that Scottish Ministers will consult on regulations under Section 3. Consultation is an important aspect of lawmaking. It helps to get the law right and ensures that the effect becomes aware of any changes in law that have their say when the law is made. Regulations under Section 3 may be used to amend the schedule to account for amendments to the Convention and of any optional protocols. At this time, we do not know what amendments to the Convention or the optional protocols might be made in the future. If such circumstances arise, we can hope that the effect of any proposed changes will get the opportunity to be involved in the actual process of amending the Convention. Even if this does not happen, the effect should be aware and an opportunity to comment on how the changes are brought about in effect. There might be alterations to administrative or practical matters which need to be put in place for the full effects to be changed. These are just some of the reasons why consultation is necessary. The Law Society of Scotland has promoted this amendment on the basis that such a wide-ranging power to amend should be consulted upon to ensure that Scottish ministers are aware of all points of view before making amendments. I wish to move amendment number 6, convener, in my name. Thank you.
Thank you, Alexander. No other members have indicated they wish to speak on this, so if I could go to the Minister, please. Minister.
Thank you, convener. Section 3 of the bill sets out the UNCRC requirements, which consist of text from the Convention and the first 2 optional protocols. Section 3 also gives the Scottish ministers the power to modify the schedule in specific ways by regulations. It's important that the Scottish ministers can modify the schedule in line with any changes to the UNCRC or its optional protocols, or if an optional protocol is ratified by the United Kingdom. It may also be appropriate to modify the schedule should the powers of the Parliament change in the future to, for example, add the articles of the Convention which are not currently included due to reasons of legislative competence. It was always envisaged that there would be a high degree of scrutiny regarding the use of such a power. As such, the power is subject to the affirmative procedure, which requires that the Parliament must approve any such modifications to the schedule before they come into effect. I agree with Alexander Stewart that given the significance of these powers and their potential impact on public authorities, ensuring a transparent and accountable approach is important. As a matter of practice, the Scottish ministers would seek views prior to the use of the power in Section 3. Therefore, convener, I am happy to support Amendment 6 and ask that the committee also give their support. It may be necessary to make some minor adjustments to the wording of the provision at Stage 3 for the purposes of consistency with the rest of the bill, and I am happy to work with Alexander Stewart on that.
Thank you, Minister. Alexander Stewart to wind up and press or withdraw Amendment 6, please.
Thank you, convener. I very much thank the Minister for her positive comments with reference to that amendment, and I look forward to working with her if that is required as we progress. I am happy to press.
Thank you. Question is that Amendment 6 be agreed to. Are we all agreed? We are agreed. The question is that Section 3 be agreed to. Are we all agreed? Committee is agreed. I call Amendment 2 in the name of Alison Harris, grouped with Amendments 7, 51 and 8. Alison Harris to move Amendment 2 and speak to all amendments in the group, please. Alison.
Thank you, convener. Amendment 2 would ensure that courts must rather than may consider these sources whilst recognising that they are not determinative. This strengthens the bill and ensures that Scotland keeps pace with the highest standards of protection internationally. This amendment also reflects the recommendation of the First Minister's own advisory group on human rights leadership, and I quote, "There must be an obligation on courts and tribunals when interpreting the rights to have regard to international law, including UN treaties, treaty body decisions, general comments and recommendations. It should also state that they may have regard to comparative law," unquote. It's widely recognised these sources are not binding sources of law. Nevertheless, they provide invaluable and authoritative interpretive analysis of how to give substance to rights contained in the UNCRC. Strengthening this provision does not mean the courts have to apply these sources. Rather, it indicates the importance that should be placed on considering these sources when interpreting the UNC requirements. I move this amendment in my name.
Thank you, Alison. Minister to speak to Amendment 7 and other amendments in the group, please, Minister.
Thank you, convener. Unlike when the Human Rights Act incorporated the European Convention on Human Rights, there is no body of case law regarding UNCRC from an international court equivalent to the European Court of Human Rights. It will take time for Scottish courts to develop their own case law in relation to interpretation of the rights and obligations being incorporated by the bill. The bill, as introduced, already recognises the importance of non-binding sources of interpretation that courts may take into account when it's relevant to determining a case. These sources include the preambles to the Convention, the first optional protocol and the second optional protocol. They also include those provisions in the Convention, the first optional protocol and the second optional protocol, which have not been incorporated by the bill because they fall out with the powers of this Parliament. As the Deputy First Minister set out in his response to this committee Stage 1 report, the Government considers that it is appropriate for the courts to retain discretion in relation to whether any sources should be taken into account in cases which come before them. Parties to a case will be able to plead the relevance of any source to the case, and it will be for the courts to then make their determination. On that basis, I ask that the committee do not support Amendment 2. The question of whether the bill should list additional sources of interpretation was a source of significant interest in discussion at Stage 1. I have listened carefully to the evidence to the committee on what additional sources should be specifically included on the face of the bill. Whilst I agree with Mary Fee that comparative law or materials which emanate from other United Nations human rights treaties may provide useful context to judicial decision-making, I believe there is a balance to be struck between signalling relevant sources to courts and tribunals and being overly prescriptive. The list at Section 4.2 of the bill is not intended to be exhausted or list every source which a court or tribunal may consider appropriate. I believe that Amendment 51 risks straying into this shopping list territory and as drafted would appear to have the effect of excluding general comment and concluding observations emanating from the UN Committee on the Rights of the Child. On this basis, I ask that the committee do not support Amendment 51. Weighing this balance, I believe there is a compelling rationale for amending Section 4 to include sources which emanate from the Committee on the Rights of the Child. As the Deputy First Minister set out at the Stage 1 debate, whilst the sources which emanate from the Committee on the Rights of the Child are not legally binding, they do provide authoritative guidance on how the articles of the UNCRC should be implemented. I believe it's important to recognise the role which the Committee on the Rights of the Child plays in supporting the effective implementation of the UNCRC across the world. Amendment 7 will expand the list of sources which Section 4.2 says a court or tribunal may take into account to include general comments, concluding observations, views and findings under the third optional protocol and recommendations following days of general discussion. Amendment 8 will remove Section 5.4, which defines the term the third optional protocol. As a result of Amendment 7, this is now defined in Section 4.2, and as such, Section 5.4 will not be required. As the Deputy First Minister said in his evidence before this committee, the bill seeks to promote a cultural change within public authorities towards children's rights. I consider these amendments to be an important element of this cultural change by signposting those sources which are directly relevant to the implementation of the UNCRC to courts and to public authorities. Convener, I move Amendment 7 and urge the committee not to support Amendments 2 and 51.
Thank you, Minister. No other member has indicated they wish to speak, so Alison Harris to wind up and press or withdraw Amendment 2, please.
Thank you, Convener. The necessity of this amendment can be demonstrated through existing case law. In recent years, courts have begun to have regard to unincorporated international treaty provisions and general comments as important sources of law and interpretation. For example, in a case before the Supreme Court challenging the benefit cap, the court cited the UNCRC protection of the best interest of the child and referred to General Comment 14 of the Committee on the Rights of the Child as providing authoritative guidance. However, this is not a routine approach for the courts, and as such, something through a must rather than may on duty on the face of the bill is appropriate, and I move this amendment in my name.
Oh. Forgive me, I did not bring in Mary Fee to speak to Amendment 51. Let me just suspend briefly to see how we sort this. If we can suspend for a minute, please. Fee, who I should have called to speak to Amendment 51 and all other amendments in the group. Mary.
Thank you, Convener. Amendment 51 in my name seeks to strengthen the bill by including jurisprudence from the wider UN treaty bodies. This would provide greater clarity for courts when they are incorporating the bill. This amendment would allow for the parameters within these treaty bodies: the United Nations Convention on the Rights of the Person with Disabilities, the Committee on the Elimination of Discrimination Against Women, the United Nations Convention of the Elimination of All Forms of Racial Discrimination, the International Covenant on Economic, Social and Cultural Rights, and the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, to act as guidance and help to clarify the content of the UNCRC. By putting an emphasis on how the UNCRC fits within the wider human rights framework, the things that they take into account will always be required to take a wider human rights approach. This would lead to a bill that considers all treaty bodies, thus making it a stronger bill for all children. And this is an amendment that has been supported by Together, and I would urge committee members to support this amendment. Thank you, Convener.
Thank you, Mary. And can I bring in Alex Cole-Hamilton, please?
Thank you, Convener. I would like to speak in favour of Mary Fee's Amendment 51, and I congratulate her for bringing it forward. I think it speaks to the fact that the UNCRC does not exist in a vacuum. It exists in an ecosystem of a range of human rights conventions, treaties and law. As such, it needs, if it is to be a genuinely living document and make rights real for Scotland's children, then it needs to act compatibly with general comments, not just of the rapporteur and the Committee on the Rights of the Child, but those comments and observations made in respect of the other treaties and rights conventions. And as such, I support Mary Fee.
Thank you, Alex. Alison, I appreciate you already gave your winding up speech, but can I ask you just to press or withdraw Amendment 2, please?
Press, Convener.
Thank you. The question is that Amendment 2 be agreed to. Are we all agreed? We're not agreed. There will be a division by roll call. When members are called, they should respond with yes, no, or abstain. Alex Cole-Hamilton.
I vote yes, Convener.
Mary Fee.
Yes.
Joe Fitzpatrick.
No.
Alison Harris.
Yes.
Gillian Martin.
No.
Alexander Stewart.
Yes, Convener.
And my vote is no. And we'll just pause for a second to confirm the numbers. Those in favour were 4, those against were 3, there were no abstentions, therefore Amendment 2 is agreed to. I call Amendment 7 in the name of the Cabinet Secretary, already debated with Amendment 2. Minister to move formally, please.
Moved.
Thank you. Question is that Amendment 7 be agreed to. Are we all agreed? We are all agreed. I call Amendment 51 in the name of Mary Fee, already debated with Amendment 2. Mary Fee to move or not move?
Moved.
Thank you. The question is that Amendment 51 be agreed to. Are we all agreed? We're not agreed. There will be a division. And called members should respond with simply yes, no, or abstain. Alex Cole-Hamilton.
Yes.
Mary Fee,
Yes.
Joe Fitzpatrick,
No.
Alison Harris,
Yes.
Gillian Martin,
No.
Alexander Stewart.
Yes.
My vote on Amendment 51 is no. And again, we'll just pause while the clerks verify the numbers. Those in favour were 4, those against were 3, there were no abstentions, therefore Amendment 51 is agreed to. The question is that Section 4 be agreed to. Are we all agreed? We are all agreed. I call Amendment 8 in the name of the Cabinet Secretary, already debated with Amendment 2. Minister to move formally.
Moved.
Thank you, Minister. The question is that Amendment 8 be agreed to. Are we all agreed? We are all agreed. The question is that Section 5 be agreed to. Are we all agreed? Committee is agreed. I call Amendment 52 in the name of Mary Fee, grouped with Amendments 9, 9A and 9B. Mary Fee to move Amendment 52 and speak to all amendments in the group. Please, Mary.
Thank you, Convener. Can I begin by moving Amendment 52? Amendment 52 in my name seeks to add greater clarity to Section 6 of the Bill. The purpose of this amendment is to ensure that all public bodies that have duties to the care of a child are covered by this Bill. Making this explicit strengthens the Bill in the interests of the children it seeks to protect. Widening this definition of a public authority to include this will give greater protection to more children and ensure that no children are missed due to a loophole in legislation. Supporting this amendment will strengthen the bill and give greater protection to children and their ability to access their rights. And Amendment 9A in my name seeks to strengthen Amendment 9 as put forward by the Scottish Government. The purpose of this amendment is to give more clarity to how functions of a public nature will meet the requirements of the UNCRC set out in my next amendment, Amendment 9B, and I would urge committee to support 9A. Amendment 9B in my name also seeks to further amend 9, put forward by the Scottish Government. My amendment will ensure that there is not an accountability gap. All children should have equal treatment, regardless of who is providing that service. By adding this amendment, the bill will require that contracts that are carried out must fulfil the rights set out in the UNCRC requirements. This will provide greater accountability and ensure that private companies acting in a public nature will not be allowed to escape the UNCRC requirements. This is an amendment which is supported by Together and by the Scottish Human Rights Commission, and I would urge you to support these amendments because it will ensure that all children are adequately protected under UNCRC requirements, regardless of whether services are carried out by a public authority or a private company acting in a public nature. Thank you, Convener.
Thank you, Mary. Minister to speak to Amendment 9 and other amendments in the group, please, Minister.
Thank you, Convener. The Scottish Government is committed to ensuring that the bill provides the highest level of protection for children's rights possible within the powers of the Parliament. I've listened carefully to the evidence at stage 1 and I agree with the committee's recommendation that the duty in section 6 of the bill should be strengthened. It has always been the Scottish Government's intention that the bill will ensure direct accountability for children's rights in relation to all functions of a public nature. One area the Scottish Government has looked at again is in relation to circumstances where functions are being undertaken by a person pursuant to a contract or other arrangement, such as a grant with a public authority. Put simply, there is a concern that children's rights will not be adequately protected when public authorities engage in contracting out. This has been described as a weakness of the equivalent provision under the Human Rights Act, where it's considered by many that the courts have taken too restrictive an approach in their construction of the term functions of a public nature. It is not the Scottish Government's intention that a similar approach should be adopted under the bill. Amendment 9 makes it absolutely clear that to the extent a person is undertaking a function pursuant to a contract or the other arrangement with a public authority, the person is caught by the duty in Section 6 not to act incompatibly with the UNCRC requirements. Anyone undertaking functions under a contract or other arrangement, such as grants, with a public authority will therefore be obliged to comply with the duty in Section 6(1) and will be directly responsible and accountable for ensuring their actions are not incompatible with the UNCRC requirements. Importantly, this does not mean that the obligations of core public authorities will be extinguished. Children will still be able to bring claims against core public authorities, but they will also be able to enforce their rights directly against providers undertaking public functions. While this is ultimately a matter for the courts to decide as the jurisprudence develops, examples of functions that we would anticipate being caught by this amendment include publicly funded early learning and childcare and publicly funded provision at independent schools and grant-aided schools. I welcome the opportunity the amendments proposed by Mary Fee give me to explain the Scottish Government's ambition further. The definition of a public authority under Section 6(3) is intentionally wide. It is modelled on the Human Rights Act and will apply to every public authority and function of a public nature to the maximum extent permitted by the powers of this Parliament, ensuring that those public authorities who provide care for children are required to comply with children's rights is already achieved by the existing definition of public authority. Amendment 52 risks introducing uncertainty in relation to those functions which are not about the care of children. That could have the consequence, and I do not think that that is the intention of Amendment 52, of narrowing the public authorities to which the compatibility duty in Section 6 applies. In relation to Amendments 9A and 9B, my understanding is that what these amendments are seeking to do is to apply the compatibility duty to certain functions which would otherwise be considered to be private in nature. It is the case in Scotland, as in many other countries, that the provisions of services to children and young people can be undertaken by public authorities and by the private sector. It is the intention of the Scottish Government that children's rights are fully respected, protected and fulfilled in Scotland, and it is my view that Section 6, as amended by Amendment 9, delivers on this. The obligations under the UNCRC, as with other international obligations, rest on the state. It is through public authorities and public functions that actions of the state are undertaken, which is why it is appropriate to place obligations directly on public authorities requiring compliance with human rights, in this case children's rights under the UNCRC. That doesn't mean, however, that business, the private and third sectors do not have an important part to play in the fulfilment of children's rights in practice, nor does it mean that there is no responsibility on the part of the private sector to ensure that rights are respected and protected. Children's rights can be and are protected in a number of different ways. For example, through the criminal law, child protection legislation, equalities legislation, and under the regulation which may apply in different sectors. In line with the UN Guiding Principles on Business and Human Rights, the Scottish Government will continue to work with those in the private sector to ensure that children's rights are fully respected, protected and fulfilled. If there are gaps in policy and regulation which require to be filled to ensure that children's rights under the UNCRC are protected, the Scottish ministers may be subject to challenge in the courts. Where courts deem that further action to protect children's rights is necessary, it would be incumbent upon the Scottish Government to take appropriate action. I understand that the policy intention behind Amendments 9A and 9B is to seek to expand the definition of public functions even further, so that the requirement to comply with children's rights would fall on parts of the private sector directly, where the core purpose of that body is the provision of services which fulfil children's rights under the UNCRC. I do not, in fact, believe that to be the effect of Amendment 9B. Amendment 9B adds to what Amendment 9 says and would, in my view, narrow its effect so that it was only contracts or arrangements which related to types of services mentioned in Amendment 9B which were captured. It's my intention that Amendment 9 should have wide application and that any provider undertaking functions with public funds as a consequence of contract and other arrangements should be required to comply with children's rights. I am concerned that 9B puts this at risk. I think there are important questions also which have not been considered by the committee in relation to any proposed extension of the compatibility duty onto what would otherwise be wholly private functions. This would be a significant expansion of the scope of the bill and one on which, through the Scottish Government's consultation and the committee stage 1 evidence, private bodies haven't been invited directly to share their views. I'm also cautious of any approach which would seek to frame the realisation of children's rights as being only the responsibility of certain services. Children's rights must be protected, respected and fulfilled in all areas of a child's life. As I've already said, I believe the bill already delivers on the Scottish Government's intention that children's rights are fully respected, protected and fulfilled in Scotland. Whilst it's my view that Amendments 9A and 9B should be rejected for the reasons I have set out, it is, of course, my intention that the bill should put in place the strongest framework possible for the realisation of children's rights. And I'm aware that stakeholders such as Together and the Scottish Human Rights Commission are supportive of the Scottish Government giving these issues further consideration, and I am happy to continue to do so. I've asked my officials to continue to engage with them and others on these questions. As I've said, I believe the bill puts in place a strong framework which will ensure the realisation of children's rights in practice in all circumstances, and Amendment 9 strengthens that framework. Where additional measures may be required to ensure that children's rights are protected, the effect of the bill will be that ministers will be required to take action, or they could potentially face challenge through the courts. It is my view that Amendments 9A and 9B should at this stage be rejected. I will, as outlined, continue to engage with relevant stakeholders and any members who wish to do so on the questions which this further debate has raised.
Thank you, Minister. If I can bring in Alex Cole-Hamilton, please. Alex.
Thank you, Convener. I'd like to speak in favour of Mary Fee's basket of amendments on this. I think that her improvement on the government's efforts here, and it is an improvement, I think is an elegant solution to the challenge that has been given to us by stakeholders in the sector about the limitations of this, the bill as drafted. We have to recognise that the public purse is spent beyond public authorities and public service delivery providers. There are a huge range of private sector companies and charities as well who perform functions in the name of the state with public funding that this Act should cover as well. And I think that I disagree with the Minister's assessment of the shortcomings, or the shortcomings as she sees them. Quite simply because these amendments have been universally endorsed by the sector, not least the Children's Commissioner, and for that reason, I am happy to support Mary Fee again.
Thank you, Alex. No other member has indicated they wish to speak, so can I ask Mary Fee to wind up and press or withdraw Amendment 52, please, Mary?
Thank you, Convener. Can I welcome the supporting comments from Alex Cole-Hamilton? And I note the comments from the Minister. My amendments do, however, reflect the views and the concerns of stakeholders that we heard throughout our evidence sessions, and I do believe these amendments are a very important addition to this bill and would give it considerable strength. And that being the case, Convener, I would like to press Amendment 52.
Thank you, Mary. Question is that Amendment 52 be agreed to. Are we all agreed? We're not agreed. There will be a division by roll call. When called, members should respond with either yes, no or abstain. Alex Cole-Hamilton,
Yes.
Mary Fee,
Yes.
Joe Fitzpatrick,
No.
Alison Harris,
Yes.
Gillian Martin,
No.
Alexander Stewart.
Yes.
My vote is no. I'll just pause for a beat while the clerks verify the numbers. There were for the amendment 4, against the amendment 3 and no abstentions. Therefore, amendment 52 is agreed to. Call amendment 9 in the name of the Cabinet Secretary. Already debated with amendment 52. Minister to move formally, please.
Moved.
Thank you. I call amendment 9A in the name of Mary Fee, already debated with amendment 52. Mary Fee to move or not move.
Moved.
Thank you. Thank you, Mary. The question is that amendment 9A be agreed to. Are we all agreed? We're not agreed. There will be a division by roll call. When called, please respond with yes, no or abstain. Alex Cole-Hamilton.
Yes.
Mary Fee.
Yes.
Joe Fitzpatrick.
No.
Alison Harris.
Yes.
Gillian Martin.
No.
Alexander Stewart.
Yes.
My vote is no. And we'll just pause while the clerks verify those. There were 4, oh, forgive me 2 seconds. There were four for the amendment, 3 against and no abstentions. Amendment 9A is agreed to. I call amendment 9B in the name of Mary Fee, already debated with amendment 52. Mary Fee to move or not move, please.
Moved.
Thank you. The question is that amendment 9B be agreed to. Are we all agreed? We're not agreed. There'll be a division by roll call. Please answer yes, no or abstain when called. Alex Cole-Hamilton.
Yes for me, convener.
Mary Fee.
Yes.
Joe Fitzpatrick.
No.
Alison Harris.
Yes.
Gillian Martin.
No.
Alexander Stewart.
Yes.
My vote is no. And again, we'll just pause, have confirmation. There were 4 for the amendment, 3 against and no abstentions. The amendment is agreed to. Minister to press or withdraw amendment 9 as amended. Minister.
Press.
The question is that amendment 9 as amended be agreed to. Are we all agreed? We are agreed. Amendment 9 is agreed to. The question is that section 6 be agreed to. Are we all agreed? Committee is agreed. Call Amendment 53 in the name of Mary Fee in a group on its own. Mary Fee to move and speak to Amendment 53, please, Mary.
Thank you, Convener. Amendment 53 in my name is based on a number of discussions that I have had with a variety of organisations, including Together and Families Outside. And I lodged this amendment as a probing amendment, and I am keen to work with the Government ahead of Stage 3 to work towards producing guidance in order to ensure that all public authorities can collaborate within the same set of guidelines. And in giving Scottish ministers the power to issue guidance to public authorities, they would be providing them with the tools that they will need to meet UNCRC requirements, and the public authorities would be obligated to follow them. There is concern from organisations such as Together, Families Outside and the Scottish Human Rights Commission that without set guidance it could lead to the UNCRC not being incorporated by all public authorities. And showing support for this amendment would lead to greater clarity for public authorities and would make the bill stronger by having greater accountability for public authorities, thus making children's rights more accessible. And I move Amendment 53. Thank you, Convener.
Thank you, Mary. No other member has indicated they wish to speak on this amendment, so I invite the Minister to contribute. Minister.
Thank you, Convener. I welcome this amendment and I'm supportive of the principle of providing clarity about the guidance and other support materials to be provided to the Scottish Government in support of implementation. My officials are already engaged with a range of public authorities and stakeholders in relation to materials which will be required to support public authorities to realise children's rights in practice. As explained in the policy memorandum, it has always been the intention that a range of guidance and materials will be developed in partnership to support effective implementation of children's rights. I am, however, concerned that Amendment 53 as drafted introduces uncertainty in relation to the responsibilities of public authorities. The requirement to not to act incompatibly with the UNCRC requirements under Section 6 is clear. Each public authority will require to consider what steps it needs to take to fulfil this duty. The final arbiter, in any case, will of course be the courts. Whilst it is intended that a range of guidance and other support will be provided to public authorities, this cannot replace the responsibility which will rest on all public authorities to ensure that they comply with children's rights. Guidance is not a substitution for considering the rights of children in all circumstances, or for public authorities being proactive in their consideration of what this means for the delivery of services to children and young people. As such, I do not consider that it is appropriate or necessary to require that public authorities should have regard to guidance issued by ministers. I am, however, supportive of making it clear on the face of the bill that guidance and other support materials can be provided by the Scottish Government in partnership with public authorities and others in support of implementation of the bill. As such, I would urge Mary Fee not to press Amendment 53 in order to allow me to explore a suitable alternative to bring before the Parliament for Stage 3.
Thank you, Minister. Mary Fee to wind up and press or withdraw Amendment 53, please, Mary.
Thank you, Convener, and I welcome the comments that have been made by the Minister, and I am encouraged by the ongoing work that is being done within Government to ensure that there is adequate guidance and instruction when this bill is enacted. And given the comments that have been made, I am happy to work with Government ahead of Stage 3 to ensure that this is that there is a set of guidance that can be followed by everyone, and I will not press my amendment.
Okay. Thank you, Mary. Are committee content that Mary Fee withdraw Amendment 53? They are. Call Amendment 10 in the name of Alexander Stewart, grouped with Amendments 11, 12, 13, 14, 15 and 18. Alexander Stewart to move Amendment 10 and speak to all amendments in the group, please.
Thank you, Convener. This is the first of a set of amendments in the group in my name. Amendment 10 ensures that Scottish ministers must make regulations under Section 7.5 if they consider such regulations to be necessary. Section 7.5 currently provides that Scottish ministers may, if they consider it necessary, to ensure that a practical tribunal can provide an appropriate remedy. The view of this, if Scottish ministers consider it is necessary for regulations to be laid in the Parliament, then the matter should not be one of ministerial discretion. The necessity of the regulations implies that it should be mandatory for ministers to make these regulations. This amendment seeks to clarify the terms in Section 7 accordingly. The effect of Amendment 11 ensures that Scottish ministers will consult on regulations before laying them under Section 7.5. As I mentioned before in regulations, to a similar point regarding Section 3, consultation is an important aspect of lawmaking. This is essential when looking for amendments and might add to the relief and remedies of a tribunal can grant on the grounds of such remedies in orders which a tribunal can make. The amendment will ensure that Scottish ministers have the full range of views before making regulations under Section 7. Amendment 12 deletes Section 9 to pave the way for Amendment 13. The Law Society and the Faculty of Advocates highlighted in their earlier evidence at the Equality and Human Rights Committee practical issues around the operation of Section 7, in particular Section 9, provides the disregard of any period of time a person reaches the age of 18 in terms of calculation of the time limits which where action may be brought forward for the section. At the extreme, this could cause litigation, also 2 decades later, where the issues and questions are no longer relevant. Early action allows for effective remedy, both in individual cases and for children more generally. The bill contains in Section 7.10 the power of the court or tribunal to disapply the 1-year time period where it is equally the same. This approach on a case-by-case basis is in the view of private solution, and which in any time before a person reaches the age of 18 can be disregarded. The purpose of bringing action, if accepted, this amendment will require amendments to Section 7.10. Amendment 13 provides that when considering under Section 1, where it is equivalent to a law, a person will consider for a tribunal must take account of any delay in the person's becoming aware of the Act and the person's age at the date of the Act. This amendment is consequential under Amendment 12, which, as I said, deletes Section 7.9. It allows the factors such as delay in becoming aware of a breach of the Convention with effects and the person of the age of the person and the date, when the court will consider. Amendment 14 ensures that any relief and remedy granted to the court or tribunal must be effective with as well and appropriate. Effectiveness is a remedy to be granted by the court as a key comment on ensuring that a statute is working and benefits for children in Scotland. Under the European Convention of Human Rights, Act 13, Article 13 provides that there are the rights and effectiveness of remedy. Article 13, however, is excluded from the terms of Schedule 1 in the Human Rights Act. Many commentators have criticised the Human Rights Act for this omission. In relation, however, to the UNCRCR, the bill, it's important to ensure that the remedies granted under legislation are in fact effective. Indeed, emphasising the requirements for relief on remedy to be effective could mitigate against purely academic points being raised. I agree with the Law Society of Scotland and the Equalities and Human Rights Committee Stage 1 report, which Section 8 should amend in this way. Amendment 15 seeks to add to Section 8 a requirement of courts and tribunals to give a child who may be affected an opportunity of expressing a view and have regard to such that child may express. The Equalities and Human Rights Committee asked the Scottish Government to amend the bill to require courts and tribunals to ask for the child's view on what would be considered an effective remedy in these cases. Like the committee, I am aware of precedent in other legislation, Section 11 of the Child Scotland Act 1995, as amended by the Children's Scotland Act 2020 when it comes into force. I believe by requiring courts and tribunals to ask for children's views in considering what will be effective remedies in cases is important in this context. A child may well want something more than damages. The amendment ensures that the court and tribunal must take into account the child's view of what will be considered an effective remedy. It is in keeping with the current child law in Scotland and provisions in the Convention that the views of the child should be taken into account when a court or tribunal is considering whether or not or to take the order concerning the child. The amendment achieves this objective. Thank you, Convener. I move the amendments in my name.
Thank you, Alexander. No other committee member has indicated they wish to speak, so can I invite the Minister to, Minister to speak to Amendment 18 and other amendments in the group. Please, Minister.
Just one moment. Thank you. Convener, Section 7 of the Bill makes provision about proceedings in relation to acts of public authorities which are incompatible with the UNCRC requirements. Subsection 5 provides a power for Scottish ministers to add to the remedies or relief of a particular tribunal if they think it necessary to do so to ensure that the tribunal can provide an appropriate remedy. Ministers can also use this power to add to the grounds on which the tribunal may grant a remedy or the orders which a tribunal may make. The power is intended to ensure that the Scottish ministers can make provision for additional remedies quickly and without having to resort to primary legislation where, in particular circumstance, it has been identified that the powers of a tribunal are not sufficient to provide a remedy for a breach of children's rights. I welcome Amendment 10 and I am supportive of it in principle. Of course, the Section 7.5 power is subject to parliamentary scrutiny through the affirmative procedure, and any draft regulations laid through the Parliament could be rejected by the Parliament. To reflect the fact that the making of regulations under Section 7.5 cannot be guaranteed by Scottish ministers, I'd like to offer to work with the member to bring forward an amendment at stage 3 to adjust this provision so that the duty on ministers is instead to lay draft regulations before the Parliament in the circumstances set out in Section 7.5. I also welcome Amendment 11, which I believe reflects this government's commitment to open and transparent decision making. It may be necessary to make some minor adjustments to the wording of the provision at stage 3 for the purposes of consistency with the rest of the bill, and I'm happy to work with Alexander Stewart on that. Convener, I ask that the committee support Amendments 10 and 11. Amendments 12 and 13 I firmly oppose. I believe that they would, if agreed, significantly reduce the protection which the bill provides for children's rights. If Mr Stewart is a champion for children's rights, he will not press these amendments. It's widely recognised that children and young people face additional barriers in realising their rights and seeking access to justice. By nature of their age and vulnerability, having the understanding, capacity and means to raise legal proceedings is likely to be more difficult for children and young people. This is particularly so for children with additional needs or those experiencing violence, abuse and trauma. The provision in relation to time limits, which Section 9 puts in place, will ensure that violations of children's rights cannot be simply dismissed because of the passage of time. The additional hurdles which Amendment 12 and 13 will put in place are not, in my view, appropriate. No child should be required to prove to court that by virtue of being a child they face additional barriers to raising legal proceedings to enforce their rights. The Deputy First Minister has spoken of the culture change which is required amongst public authorities if we are truly to realise our ambition that children's rights are fully protected, respected and fulfilled. The provision in Section 7 on time limits is part of that culture change. Children and young people spend significant parts of their life under the care of and in receipt of public services from public authorities. Public authorities must be ready to listen and learn from the children and young people whom we serve. This includes recognising the significant power imbalance that exists between children and public authorities and ensuring that children are fully supported to realise their rights throughout their childhood. Section 7 will not prevent claims being raised quickly where it is possible and in the interest of children and young people to do so, but it ensures that every opportunity is given to children and young people to hold public authorities to account. That is something that should be supported by all members who support children's rights. I'm supportive of Amendment 14, which ensures that there is transparency in relation to the Court's consideration of effective remedies. I'm supportive of the policy intention behind Amendment 15. However, the Scottish Government has lodged Amendment 18, which is intended to achieve the same result, but is, in my view, clearer. Both amendments seek to ensure when a court is considering effectiveness of remedies that, in line with Article 12 of the UNCRC, the court has the child's views. Amendment 18 is, in my view, stronger than Amendment 15. It will ensure not only that children are afforded the opportunity to express their views, but that they should be able to do so in the manner which they prefer or is suitable for them. It also makes clear, in line with Article 12, that the child should be presumed to be capable of forming views. Convener, I move Amendment 18.
Thank you, Minister. No other members indicated they wish to speak, so can I ask Alexander Stewart to wind up and press or withdraw Amendment 10, please. Alexander.
Thank you, Convener. I'm encouraged by the Minister's comments with reference to this section, and I am looking forward to working with the Minister on some of these as we progress. So I am happy to press Amendment 10.
Thank you. The question is that Amendment 10 be agreed to. Are we all agreed? Committee agrees to Amendment 10. I call Amendment 11 in the name of Alexander Stewart, already debated with Amendment 10. Alexander Stewart to move or not move?
Move, Convener.
Thank you. The question is that Amendment 11 be agreed to. Are we all agreed? Committee is agreed. I call Amendment 12 in the name of Alexander Stewart, already debated with Amendment 10. Alexander Stewart to move or not move?
Move, Convener.
Thank you. The question is that Amendment 12 be agreed to. Are we all agreed? We're not agreed. There will be a division by roll call. When I call your name, please respond with yes, no, or abstain. Alex Cole-Hamilton.
No.
Mary Fee.
No.
Joe Fitzpatrick.
no,
Alison Harris.
Yes.
Gillian Martin.
No.
Alexander.
Yes.
My vote is no. And we'll just take a second while clerks confirm. There were 2 for the amendment, 5 against the amendment. There were no abstentions. The amendment is not agreed. I call Amendment 13 in the name of Alexander Stewart, already debated with Amendment 10. Alexander Stewart to move or not move?
Move, Convener.
Thank you. The question is that Amendment 13 be agreed to. Are we all agreed? We're not agreed. There will be a division. When I call your name, please respond yes, no, or abstain. Alex Cole-Hamilton.
No, Convener.
Mary Fee.
No.
Joe Fitzpatrick.
no,
Alison Harris.
Yes.
Gillian Martin.
No.
Alexander Stewart.
Yes.
My vote is no. We'll just take a second while clerks confirm. There were 2 for the amendment, 5 against, and no abstentions. Amendment 13 is not agreed to. The question is that Section 7 is agreed to. Are we all agreed? We are agreed. Call Amendment 14 in the name of Alexander Stewart, already debated with Amendment 10. Alexander Stewart to move or not move?
Move, Convener.
Thank you. The question is that Amendment 14 be agreed to. Are we all agreed? Committee is agreed. Call Amendment 15 in the name of Alexander Stewart, already debated with Amendment 10. Alexander Stewart to move or not move?
Not moved, convener.
Thank you. I now call Amendment 16 in the name of the Cabinet Secretary, grouped with Amendments 17, 19, 27, 28, 39, 40, 42 and 43. Minister to move Amendment 16 and speak to all amendments in the group, please. Minister.
Just one moment. Thank you, convener. I move the amendments. The bill recognises the additional barriers which are faced by children and young people and the need to ensure that justice is accessible for them. As such, it provides the Children's Commissioner with the power to bring proceedings in the public interest and to intervene in proceedings which a person claims that a public authority has acted or proposes to act in a way that is incompatible with the UNCRC requirements. It also requires the courts to notify the Children's Commissioner where a court is considering to make a strike-down declarator on an incompatibility declarator in relation to legislation or where a compatibility question arises in any proceedings before a court or tribunal. We've noted the written evidence of the Scottish Human Rights Committee seeking similar powers as the Children's Commissioner to raise or intervene in proceedings. I consider this to be in line with our maximalist approach to incorporation. Amendment 19 will modify the Scottish Commission for Human Rights Act 2006 to disapply the existing prohibition on existing in claims or legal proceedings, but only in relation to proceedings under this bill. The approach will bring the SHRC into the bill's framework in the same way as the Children's Commissioner, providing parity of esteem. Amendments 39, 40, 42 and 43 will mean the bill meets the same provision in relation to the SHRC as it does for the Commissioner and will further support children and young people to fully realise their rights and access justice. Amendments 16 and 17 will amend Section 8(5) of the bill so that no award of damages is to be made to the SHRC. Amendments 27 and 28 will require Scottish ministers to consult the SHRC when publishing or amending the Children's Rights Scheme and when publishing a report under Section 13 respectively. These will strengthen the SHRC's existing functions by providing the power to raise litigation in the public interest and placing requirements on courts to notify the SHRC of certain proceedings. This will enable the SHRC to bring cases to court without the need for individual children and young people or their families to take on the full responsibility and strain of bringing challenging cases to court on their own. The amendments will also enable the SHRC to intervene in certain proceedings where it's appropriate for it to do so. This approach recognises the SHRC's status as one of Scotland's national human rights institutions and is in line with the bill's intention to support children and young people to assert and defend their rights and the rights of others. Convener, I move Amendment 16.
Thank you, Minister. No member has indicated they wish to speak. Minister, do you need to wind up or are you happy to proceed? Okay, the question is that Amendment 16 be agreed to. Are we all agreed? Committee is agreed. Call Amendment 17 in the name of the Cabinet Secretary, already debated with Amendment 16. Minister to move formally, please.
Move.
Thank you. The question is that Amendment 17 be agreed to. Are we all agreed? Committee is agreed. Question is that Section 8 be agreed to. Are we all agreed? We are. Call Amendment 18 in the name of the Cabinet Secretary, already debated with Amendment 10. Minister to move formally, please.
Moved.
Question is that Amendment 18 be agreed to. Are we all agreed? Committee is agreed. Question is that Sections 9 and 10 be agreed to. Are we all agreed? We are. Call Amendment 19 in the name of the Cabinet Secretary, already debated, with Amendment 16. Minister to move formally, please.
Moved.
Thank you. The question is that Amendment 19 be agreed to. Are we all agreed? We are agreed. I call Amendment 20 in the name of the Cabinet Secretary, grouped with Amendments 21, 22, 54, 55, 56, 23, 24, 25, 26, 57, 58 and 61. Minister to move Amendment 20, please, and speak to all amendments in the group. Minister.
Thank you, Convener. As the Deputy First Minister set out at the Stage 1 debate, the Scottish Government is happy for the scheme to require ministers to include and report on the topics listed in Section 11.3. On that basis, I urge the committee to support Alexander Stewart's Amendment 22 that would make the list of matters listed in Section 11.3 mandatory. Indeed, had the member not lodged this amendment, I would have done so myself. As the Deputy First Minister also set out at the Stage 1 debate, it is the intention of this Government to strengthen the scheme by requiring it to include arrangements to promote a child-friendly complaints mechanism and ensure effective access to justice for children and young people. The list at Section 11.3 of the Bill is not intended to list every action which ministers will take in fulfilment of the compatibility duty in Section 6, but is intended to highlight key strategic priorities which should always be included. The scheme will be consulted on and revised annually, so there will be an annual opportunity for more granular priorities which are likely to change over time to be recognised. Ensuring that children and young people can realise their rights and access justice is vital not only to the success of the bill, but to driving the desired culture change in Scotland. Amendment 24 will require the ministers to set out in the scheme arrangements to ensure effective access to justice for children. This will include matters such as legal aid, but importantly is wider than this. There's a requirement already in Section 11.3a for ministers to set out arrangements which will ensure that children are able to participate in decisions which affect them. Where children require access to independent advocacy in order to be able to participate fully in decision making, this is the type of measure that can be reported on under this requirement. Again, I consider that the provision at Section 11.3a is broader, so that other matters relevant to children's participation are also prioritised. For these reasons, I would urge members to support Amendment 24 and to ask Mary Fee not to press Amendments 54 and 55. We know that the provision of accessible complaints mechanisms are an important part of realising children's rights in practice. Indeed, for many children and young people, complaints mechanisms are likely to be the route by which children's rights issues can be aired without recourse to the courts or tribunal system. In recognition of this, I believe it's important the action taken by Scottish ministers to promote accessible complaints mechanisms should form part of the Children's Rights Scheme. Amendment 23 will ensure this is included in the requirements for the scheme. Through the scheme, this Government intends to build in greater accountability and transparency in relation to the proactive realisation of children's rights. To support that aim, Amendment 25 requires ministers to address arrangements for the publication of the CRIAs in the scheme so that these can be consulted on and reviewed on an annual basis. I've listened carefully to the evidence of the committee and suggested additional requirements for specific inclusion in the scheme, including a specific provision about protected characteristics in children who are in situations of vulnerability. Whilst I am of the view that ministers will already be required as a consequence of the compatibility duty in Section 6 to demonstrate how they ensure the rights of all children and young people without discrimination, I have listened carefully to the views of those who represent the views of children who are often the least heard. They have emphasised that specific requirements matter to them to ensure that their separate rights and needs are systematically prioritised. I therefore welcome Amendments 56 and 57 and am supportive of them in principle. I understand the importance that this amendment has to Together and other stakeholders who represent in particular children with disabilities or care experienced children and young people. I also recognise the importance of ensuring that children with protected characteristics and situations of vulnerability should be specifically recognised within the scheme. I've asked my officials to give the drafting of these amendments careful consideration and to work in partnership with Mary Fee and members of Together to ensure that they achieve their intended purpose. It is possible I may seek to bring forward adjustments at stage 3 to make sure it all works as well as it can. I do not consider that Amendment 61 is necessary because it duplicates the definition provided by Amendment 57 and would urge Mary Fee not to press it. Regarding Amendment 58, I've given careful consideration as to its necessity. Section 13 requires Scottish ministers to review and report on the scheme. I therefore do not think it is strictly necessary to repeat in Section 13 the matters which must be included in the scheme and which are set out in Section 11. The other matters which are to be included in the scheme are not repeated in Section 13. I believe that by supporting Amendment 56, the policy intention which I understand Mary Fee is seeking to deliver on with Amendment 58, that is, that these matters will be included in the scheme and will become part of the annual review and reporting cycle in the scheme, is delivered. I would therefore suggest it is not necessary to press Amendment 58. My intention is that the scheme will function as a transparent mechanism of how children's rights are embedded by Scottish ministers in practice and will provide a model which public bodies can follow. The UNCRC is, of course, not the ceiling of our ambitions. It is my intention that through the scheme, ministers should set out arrangements for how they progressively realise the rights of children and young people in line with international obligations. Amendment 21 builds upon the current requirement of children and young people at 2014 and builds into the scheme requirements proactive consideration of what steps ministers can take to give better and further effect to the rights of children. In this way, we will ensure that Scottish ministers continue to fulfil their role as leaders in children's rights by seeking to progressively realise those rights. I do not consider that Amendment 26 is necessary. It is intended that the first children's rights scheme will be in place on commencement. Convener, I move Amendment 20 and encourage members to support Amendments 21, 22, 23, 24, 25, 56 and 57. I hope that Alexander Stewart accepts that his Amendment 26 is not now needed and will not press it. Should he do so, I hope that members will recognise our intent to make the scheme ahead of commencement and vote against it. Likewise, I hope that Mary Fee recognises that Amendment 57 being accepted makes Amendment 58 obsolete and will not press that. The same applies to Amendment 61. While it would be the government's preference for Amendment 58 not to be passed, should members be minded to support it, I am sure we will be able to accommodate it. Though, of course, we will give that further consideration ahead of stage 3. I also hope that Mary Fee will not press Amendments 54 and 55 on the basis that the intent behind both are covered. Amendment 54 by the existing provision in Section 11 and Amendment 55 by the Government's Amendment 24. Should these amendments be pressed, I would encourage members not to support Amendments 54 and 55. Thank you.
Thank you, Minister. Member Stewart to speak to Amendment 22 and all other amendments in the group, please. Alexander.
Thank you, Convener. Amendment 22 seeks to amend Section 11.3 to ensure that Children's Rights Scheme requires the inclusion of certain obligations on Scottish ministers regarding the rights of children. Section 11 requires Scottish ministers to make Children's Rights Scheme, setting out the arrangements to ensure Scottish ministers comply with their duties under Section 6. Section 11.3 provides the scheme may include arrangements for Scottish ministers to ensure that examples of children are able to participate in making decisions that affect them, and the ministers raise awareness of any promote of rights child. The Equality and Human Rights Committee noted that the representations and call for views from oral evidence suggested that the language in Section 11 needs to be strengthened. I also acknowledge the Government's response to the committee, accepting that the wording in Section 11 may change from may to must. I and the Law Society of Scotland agree with the proposals in this amendment, and it achieves its objective. Amendment 26 ensures that there is a time limit for the publication for the first report from the Children's Rights Scheme. In the review of the Law Society of Scotland, it is important that Children's Rights Scheme to be quickly, and that will be adequate for Parliament scrutiny in operations under Section 11.4. The first scheme must specify the date of which it was first reported. Convener, I note the comments made by the Minister, and I am happy to incorporate that as we move forward. Thank you.
Thank you, Alexander. I call Mary Fee to speak to Amendment 54 and other amendments in the group, please, Mary.
Thank you, Convener. And before I begin, can I say that I've listened carefully to the comments that the Minister has just made, and in light of those comments, I will speak to, but I will not move 54, 55, 58 and 61, but I do wish to speak to the intention behind my amendments. Amendment 54 in my name would strengthen the bill by ensuring the Children's Rights Scheme gives greater control to children by giving them access to independent advocacy services. And this would mean that children would always have access to impartial information that will help them when they are making decisions that affect them. And this would add an extra level of protection for children. Amendment 55 sought to ensure that children have access to legal aid as part of the Children's Rights Scheme. And this would have strengthened the bill as it allows for children to use their rights regardless of their financial circumstances. And this would help make the bill one that is inclusive for all children in Scotland. Amendment 56 would ensure that all children have their rights respected, protected and fulfilled. Children who have one or more protected characteristic or who are in a situation of vulnerability may be less likely to have their rights respected, protected and fulfilled due to discrimination. By putting this amendment in the bill, it would ensure that these children have their rights respected as part of the scheme and gives them greater protection and makes the bill far stronger for vulnerable children. Amendment 57 gives greater clarity to the bill by defining what is meant by protected characteristics. And using the characteristics listed in section 149(7) of the Equality Act 2010 means there is little room for interpretation. And this is an important change because it's crucial that all children feel properly supported. And using an established list from the Equality Act gives reassurance that there are no characteristics that can be ignored and that the understanding of the incorporation of the UNCRC is rooted in established equalities legislation. This is a bill that must guarantee that all children in Scotland are adequately protected. Amendment 58 in my name strengthens the bill by ensuring that Scottish ministers must include a summary of actions they have taken to ensure that children who have one or more protected characteristic are in a situation of vulnerability have their rights respected, protected and fulfilled in their reports. This means that greater accountability for children's rights from Scottish ministers will be required, thus making the bill stronger for the children it seeks to protect. And Amendment 61 seeks to provide greater clarity to the bill. The amendment follows Amendment 57 in my name by ensuring that any mention of protected characteristics throughout the bill is defined by the Equality Act 2010. In accordance with Amendment 57, it will give the bill a cohesive understanding of the definition of protected characteristics, leaving no room for interpretation. Thank you, Convener.
Thank you, Mary. No other members have indicated they wish to speak in this section. Can I ask the Minister to wind up, please, Minister?
Thank you, Convener. The Children's Rights Scheme is a really important part of the framework which the bill puts in place, and it will ensure that there's regular consideration and scrutiny of the steps which ministers must take to ensure the children's rights are proactively and progressively realised in practice. As I've said, I believe there's a balance to be struck between the level of specificity which it is appropriate to include in the face of legislation and the need to ensure that what the bill does is put in place a framework which can endure into the future and is responsive to the priorities of the day. I'm grateful for the spirit that has been expressed by colleagues on the committee, and I'm keen to work further with them before stage 3 to ensure that this section delivers on our ambition.
Thank you, Minister. The question is that Amendment 20 be agreed to. Are we all agreed? We are agreed. Call Amendment 21 in the name of the Cabinet Secretary, already debated with Amendment 20. Minister, to move formally, please.
Formally moved.
Thank you. The question is that Amendment 21 be agreed to. Are we all agreed? We are agreed. I call Amendment 22 in the name of Alexander Stewart, already debated with Amendment 20. Alexander Stewart to move or not move?
Moved, convener.
Thank you. The question is that Amendment 22 be agreed to. Are we all agreed? Waiting to see everyone's faces. We are all agreed. I call Amendment 54 in the name of Mary Fee. Mary, forgive me, you indicated, did you move or to move or not move?
Not move. Not
Not
move.
move. Thank you, Mary. I call Amendment 55 in the name of Mary Fee, already debated. Mary Fee to move or not move?
Not moved.
Not moved. I call Amendment 56 in the name of Mary Fee, already debated with Amendment 20. Mary Fee to move or not move?
Moved.
The question is that Amendment 56 be agreed to. Are we all agreed? Committee is agreed. I call Amendments 23, 24 and 25, all in the name of the Cabinet Secretary and all previously debated. I'll invite the Minister to move Amendments 23 to 25 on block.
Moved on block.
Does any member object to a single question being put on Amendments 23 to 25? No, members are content. The question is that Amendments 23 to 25 are agreed. Are we all agreed? We are agreed. Call Amendment 26 in the name of Alexander Stewart, already debated with Amendment 20. Alexander Stewart to move or not move?
Not moved, convener.
Not moved. I call Amendment 57 in the name of Mary Fee, already debated with Amendment 20. Mary Fee to move or not move?
Moved.
Thank you. The question is that Amendment 57 be agreed to. Are we all agreed? We are all agreed. The question is that Section 11 be agreed to. Are we all agreed? We are agreed. Colleagues, that seems like a good place to stop for a quick comfort break. So what I'll do is suspend for around 5 minutes to allow a comfort break. We can suspend now, please. Welcome back. Can I now call Amendment 27 in the name of the Cabinet Secretary, already debated with Amendment 16. Minister to move formally, please.
Formally moved.
The question is that Amendment 27 be agreed to. Are we all agreed? We are agreed. Question is that Section 12 be agreed to. Are we all agreed? We are agreed. I call Amendment 58 in the name of Mary Fee, already debated with Amendment 20. Mary Fee to move or not move?
Not moved.
Thank you. I call Amendment 28 in the name of the Cabinet Secretary, already debated with Amendment 16. Minister to move formally, please.
Move formally.
Thank you. The question is that Amendment 28 be agreed to. Are we all agreed? We are agreed. I now call Amendment 47 in the name of Gillian Martin, grouped with Amendments 49, 5 and 50. Gillian Martin to move Amendment 47 and speak to all amendments in the groups, please. Gillian.
Thank you, Convener. Throughout the committee's many outreach sessions, I was struck by how many young people said that their rights had not been properly communicated to them at certain crucial points in their life. And in particular, the care experienced young people that we spoke to were very firm in their calls for all policies and decisions relating to children to be available in child-friendly language. So throughout our formal evidence sessions, I pursued this line of inquiry, and I was convinced of the need for all reports relating to children and young people to be made available to them in a language that they can understand. In response to questions to me in his evidence to the Equalities and Human Rights Committee at Stage 1, the Deputy First Minister agreed on the importance of ensuring that the requirements in the bill are translated into a meaningful and easily understood message to children and young people. They need to know what their rights are and how to pursue their rights, and they have a better chance of doing this if communication on those rights is appropriate for the age. The achievement of this ambition is fundamental to ensuring that children and young people are empowered to understand their rights, and confirming and enabling that understanding should be central to how public authorities building a rights-respecting culture which centres the rights of the child is made. As introduced, Section 13 provides that ministers must review and report on the operations of the Children's Rights Scheme on an annual basis. It requires that ministers must prepare and publish a version of the report that they consider will be understood by children. Amendment 47 will strengthen this provision to require that ministers produce a version which children can understand, which is much stronger. Amendment 49 will require that reports under Section 15 by listed public authorities about actions they have taken for the purpose of ensuring compliance with the duty under Section 6 is accompanied by a version which children can understand. Amendment 50 will place the same requirement on reports published by Scottish ministers under Section 23 following a strike down or incompatibility declarator. This is an area that I know that Alison Harris also wishes to see the bill to be strengthened. However, I do consider that my amendment is stronger as it says reports must be produced which children can understand, and has phrasing which is more consistent with my amendments 47 and 49. Ms Harris's amendment has a similar objective, but has the phrasing which ministers consider, which I don't believe is as definitive or as robust. Therefore, I ask the committee not to support Amendment 5 and hope that Ms Harris and the rest of my colleagues understand why my amendment is stronger and more in keeping with our shared objectives in communicating appropriately with children on their rights. Convener, I move Amendment 47 in my name and ask that the committee support Amendments 47, 49 and 50. Thank you.
Thank you, Gillian. Alison Harris to speak to Amendment 5 and other amendments in the group. Alison, please.
Thank you, Convener. Whilst I've listened to Gillian Martin speak, I feel that my amendment, Amendment 5, is the most child-friendly focused option, because it does require that Scottish ministers publish a report that children can understand. But given that the report will be about the steps being taken to address a breach of children's rights, it's only right that this report is primarily one which children do and can understand. My amendment would ensure that there is only one report prepared, as Gillian Martin, my understanding is, requires 2 reports, an adult report and a child-friendly report. So I would say my amendment is more appropriate. Thank you. I'd like to move it in my name.
Thank you, Alison. No other members have indicated they wish to speak. Can I invite the Minister's comments, please? Minister.
Thank you, Convener. Convener, I welcome and support Amendments 47 and 49 in the name of Gillian Martin, which ensure that reports on the Children's Rights Scheme under Section 13 and reports under Section 15 about action taken by public authorities for the purpose of ensuring compliance with the duty under Section 6.1 will require to be communicated in a way that children can understand. I also welcome and support Amendment 50, which will ensure that reports published by Scottish Ministers under Section 23 following a strike down or incompatibility declarator are also communicated in a way that children can understand. Whilst I support the intention behind Amendment 5, I consider that the amendment lodged by Gillian Martin is clearer and more consistent with the phrasing of Amendments 47 and 49. Convener, I ask that the committee support Amendments 47, 49 and 50.
Thank you, Minister. Gillian Martin to wind up and press or withdraw Amendment 47. Gillian, please.
Thank you, Convener. I'm going to press Amendment 47. I'd just like to say that there is a range of ages of children that might be wanting to access reports, and child-friendly language is appropriate for young children, but also a report is also available in language that older children and young people can understand is also important too. But my main reasoning is that Alison Harrison's amendment has which ministers consider. My approach is much stronger. It actually puts a compulsion on that children can understand, which is more objective and I believe a lot stronger.
Thank you, Gillian. The question is that Amendment 47 be agreed to. Are we all agreed? We are agreed. The question is that Section 13 be agreed to. Are we all agreed? We are agreed. Call Amendment 29 in the name of the Cabinet Secretary, grouped with Amendments 30, 31, 32, 33, 48 and 34. Members should note that Amendment 32 preempts Amendment 33, and if Amendment 32 is agreed to, I cannot call Amendment 33. Minister to move Amendment 29 and speak to all amendments in place.
Convener, I'm aware that concerns were raised to committee regarding Section 14.3 of the bill and the level of discretion afforded to ministers in relation to decisions of a strategic nature for which a child rights and wellbeing impact assessment must be undertaken. Undertaking rigorous impact assessments at all levels of government and public administration will be an important part of how public authorities demonstrate their compliance with the compatibility duty in Section 6 and demonstrate how they respect, protect and fulfil children's rights in practice. The bill on introduction placed a requirement on ministers to undertake a CRIA in relation to such decisions of a strategic nature as they are considered appropriate. Amendment 33 will strengthen this provision by removing the references to ministerial discretion and requiring ministers to set out the detail on the strategic decisions for which they will prepare and publish a CRIA in the Children's Rights Scheme. This was always the policy intention. As members will be aware, Alexander Stewart's Amendment 22, which I support, will adjust Section 11.3 to make the list of matters to be included in the scheme mandatory. When combined with our Amendments 29, 30 and 33 and Mr Stewart's Amendment 31, which I also support, this will place a duty on ministers to publish the CRIA prepared in relation to legislative provision or decisions of a strategic nature in accordance with the requirements and arrangements as are set out in the Children's Rights Scheme. The effect of these amendments will be to ensure ongoing transparency and accountability in relation to how the Scottish ministers consider and make provision for children's rights in their strategic decision-making in practice. Mr Stewart's Amendment 32 appears to have a similar aim to my Amendment 33, but it doesn't make it as clear that when and how CREAs must be prepared and published requires to be done in accordance with arrangements in the scheme. I would therefore ask him not to press that amendment, and instead support the Government's Amendment 33. I can assure the committee that this Government will continue to work with public authorities to encourage best practice of ensuring their CREA processes are accessible, involve consultation with children and young people, and are published in child-friendly formats where appropriate. As the Deputy First Minister said in his appearance before this committee, the impact of the COVID-19 pandemic has been felt acutely by children and young people, and it has disrupted their lives in previously unimaginable ways. This Government has ensured that children's rights are at the heart of our COVID response. Throughout the pandemic, decisions have often needed to be taken at pace. However, we have sought to strike the important balance between the health and well-being of school and wider communities, alongside the clear benefits that education and school brings. A suite of impact assessments, including a CREA on school closures and their reopening in August, have been published and are currently being updated to take into account variances with the current situation. Members of the COVID-19 Education Recovery Group, which includes a member of the Scottish Youth Parliament, have provided insight for this work. This has also been supported by discussions with the Children's Commissioner, meetings between the Deputy First Minister and groups of learners in June, October and December 2020, and input from multiple stakeholders. This was further strengthened in November 2020 with the creation of Education Recovery Youth Panel, comprising 25 children and young people aged 9 to 18. The Deputy First Minister met with the panel on the 4th of February, and they will continue to engage with ministers in the COVID-19 Education Recovery Group throughout the spring and summer 21, helping to influence and shape our approach to education recovery. By establishing a framework for children's rights in Scotland, this bill is essential to our recovery and to the fairer, more equal society that the Government wants for Scotland's future beyond our recovery. Whilst I do not consider that Amendment 48 is necessary, I am content for the provisions to be made which would require ministers to prepare children's rights and wellbeing impact assessment in relation to decisions about school closures in the context of the COVID pandemic on the face of the bill. I have asked my officials to give the drafting of the amendment careful consideration and consider that some adjustment at stage 3 will be required. However, I am supportive of it being accepted today. Convener, I move Amendment 29 and urge members to support my other amendments in this group, along with Amendment 31 in Mr Stewart's name and Amendment 48 in Rachel Hamilton's. I would ask members not to support Amendment 32, however, as I believe that the Government Amendment 33 offers a better solution here. Thank you.
Thank you, Minister. I call Alexander Stewart to speak to Amendment 31 and other amendments in the group. Alexander.
Thank you, Convener. I move Amendment 31 and will speak to Amendment 32. These amendments ensure that Scottish ministers are under a direct obligation to prepare a child rights and wellbeing assessment in relation to all strategic decisions relating to the rights and wellbeing of children. Section 14.3 obliges Scottish ministers to provide a child's rights as well impact assessment in relation to such decisions in relation to the rights and wellbeing of children as they consider appropriate. The Equalities and Human Rights Committee asked the Scottish Government at stage 1 to remove ministerial discretion on section 14.3 of the bill. If this is not removed, the committee wanted the Scottish Government to provide clear information around the decisions and the strategy and the nature that would take place to considering appropriate use of a CRWIA to be carried out. I agree with the Committee on Law Society of Scotland, who take the view that section 14 affords Scottish ministers sufficient discretion regarding what is considered appropriate, and therefore the impact assessment would appear. Having read the Government's response at stage 1, I welcome the comments that the Minister has made this morning with reference to section 32, and I will not be pressing that. Thank you, Convener.
Thank you, Alexander. I now call Rachel Hamilton to speak to Amendment 48 and other amendments in the group. Rachel, please.
Thank you, Convener, and I want to thank the committee for giving this opportunity to speak to my amendment. Over the past year, due to COVID-19, children's rights to education have been compromised with the closure of schools. To save lives and protect the NHS, immediate closure of schools was unavoidable. However, The ongoing pandemic has seen a substantial impact on children's rights due to these actions, with their learning interrupted, and I believe the impact was not properly assessed. Parents, teachers and pupils across Scotland had patchy access to resources such as digital and physical, and many struggled to access broadband. Furthermore, in worst case scenarios, some children found themselves in a vulnerable position at home all day compared to in school, where mental and physical wellbeing can be assessed. Although the Scottish Government published a children's rights and wellbeing impact assessment on some of the legislation passed around the pandemic, it is important that assessments are done comprehensively and cover all law and policy that affects children. It was highlighted in the Getting Right report by this committee in 2018 that the Scottish Government amend its practice for all Scottish Government bills. It says, and I quote, "The Scottish Government should, in conjunction with the Parliament, the Scottish Human Rights Commission, the Equalities and Human Rights Commission and the Children and Young People's Commission of Scotland, agree a template for an impact and opportunity assessment." This was suggested years ago, and an impact assessment was carried out for the schools opening in August. However, there was no assessment done prior to that. And I want to thank the Commissioner, Bruce Adamson, and the Observatory of Children's Human Rights for their own independent assessment, which highlighted these issues. It has become clear through evidence given to the committee that as we incorporate the UNCRC in Scots law, we seek to strengthen the duty on the Scottish Government to properly assess any future decision making on school closures or the disruption of education as a result of COVID. And where access to education is restricted, it should be the case that ministers must prepare a child right and wellbeing impact assessment to ensure we do not see a rerun of the issues of last year or repeat, creating the same exam result issues for next year's cohort, as mentioned by Dr. Tracy Kirk. Some children have been let down badly under the current circumstances, and my amendment seeks to address this. And what underpins my amendment, in short, is a duty on ministers to properly prepare impact assessments in the context of UNCRC, and thus doing so avoid a situation arising where schools closure compromise a child's access to education as outlined in Article 28. And I move the amendment in my name.
Thank you, Rachel. No other member has indicated they wish to speak. Can I invite the Minister to wind up, please?
Thank you, Convener. I would simply say that ensuring child rights and wellbeing impact assessments are undertaken meaningfully and informed decision making across the public sector is absolutely essential. And I believe the bill strikes the right balance by ensuring that there is direct accountability on ministers in relation to legislation and strategic decisions, and ensuring that the Scottish Government can continue to work with public authorities to ensure the best practice in relation to impact assessments is followed without reducing the assessment to a tick box process. I believe the Scottish Government's amendments and those which I'm supporting will mean that the bill is strengthened in the interests of children and young people, and I'm grateful to committee members for their support. Thank you.
Thank you, Lisa. The question is that Amendment 29 be agreed to. Are we all agreed? We are agreed. I call Amendment 30 in the name of the Cabinet Secretary, already debated with Amendment 29. Minister to move, please.
Moved.
Thank you. The question is that Amendment 30 be agreed to. Are we all agreed? We are agreed. I call Amendment 31 in the name of Alexander Stewart, already debated with Amendment 29. Alexander Stewart to move or not move?
Move, Convener.
Thank you. The question is that Amendment 31 be agreed to. Are we all agreed? We are agreed. I call Amendment 32 in the name of Alexander Stewart, already debated with Amendment 29. Alexander Stewart to move or not move?
Not move, Convener.
Thank you. Amendment 32 is not moved. I call Amendment 33 in the name of the Cabinet Secretary, already debated with Amendment 29. Minister to move or not move, please.
Moved.
Thank you. The question is that Amendment 33 be agreed to. Are we all agreed? We are agreed. I call Amendment 48 in the name of Rachel Hamilton, already debated, with Amendment 29. Rachel Hamilton, to move or not move?
Moved. Thank you, Convener.
Thank you. The question is that Amendment 48 be agreed to. Are we all agreed? Committee is agreed. I call Amendment 34 in the name of the Cabinet Secretary, already debated, with Amendment 29. Minister, to move formally, please.
Moved.
Thank you. The question is that Amendment 34 be agreed to. Are we all agreed? Committee is agreed. Question is that Section 14 be agreed to. Are we all agreed? Section 14 is agreed to. I call Amendment 35 in the name of the Cabinet Secretary, grouped with Amendments 36, 37, 59 and 60. Minister, to move Amendment 35 and speak to all amendments in the group, please. Minister.
Convener, Section 15 of the bill, as introduced, places a requirement on listed authorities to prepare and publish reports on what they have done to comply with the duty in Section 6.1 of the bill on a 3-yearly basis. The purpose of this duty is to ensure that there is transparency and accountability for the actions and plans of those authorities whose services most directly affect children and young people. In their evidence before this committee, some rights stakeholders called for the approach to the bill to be strengthened by requiring the Section 15 duty on listed authorities to be not just retrospective in effect, but also proactive, and to require them to report on their planning for the next reporting period, as well as what they had done in the previous period. As was set out in our response to the report, Scottish Government agreed with the committee's recommendation and pledged to bring forward an amendment to achieve this effect. I consider that requiring listed authorities to also set out and report on their plans for the next 3-year period will help promote a culture of everyday accountability for children's rights, and this is how public authorities would work in any case. As you'll be aware, Section 2 of the Children and Young People Act, Scotland 2014, currently contains a duty on certain public authorities to report on steps to taken to secure better or further effect within its areas of responsibility of the UNCRC requirements. On introduction, the bill repealed Section 2 in its entirety, along with the rest of Part 1 and Schedule 1, and replaced it with what is now Section 15 in the bill. These amendments also amend Section 15 of the bill to provide that, as well as reporting on what actions they have taken to comply with the duty in Section 6.1, listed authorities will be required to report on what actions they have taken to secure better or further effect of the rights of children. The intention here is that Section 15 should also reflect the wider duty and intention underpinning the duties in Section 2 of the 2014 Act, and ensure that the consideration of the progressive realisation of children's rights is at the heart of listed authorities' actions and planning considerations. Therefore, Government's Amendments 35 to 37 not only fulfil the recommendation of this committee, but go further and require listed authorities to set out and report on their actions to give better and further effect to the rights of children. As the Government has done for the existing reporting duty under Section 2 of the Children and Young People Scotland Act 2014, we will work in partnership with a range of public authorities in relation to the guidance which will be required to support them fully realise children's rights in practice. I have sympathy with the intention behind the amendments 59 and 60. However, in placing additional requirements on public authorities, we are mindful of the need to achieve the right balance, avoiding placing undue administrative burdens on public authorities, and I consider that the intended effect of these amendments would be better achieved by effective guidance and partnership working between government, relevant stakeholders and public authorities, and with children and young people themselves. This is the way to ensure that the reports contain the right information tailored to the circumstances of the authority in question, and where that is appropriate, it can deal with the matters that the member is concerned about. I know that members will want to do more in the face of the bill to recognise and provide for the needs of children in what is reported, and I too share that aspiration. For these reports to be meaningful, they must address a range of issues relating to children, but to prescribe in primary legislation some matters and not others, as Mary Fee's amendments do, will not necessarily serve the best interests of children. However, I'm keen to explore and consider these matters further ahead of stage 3, so I would ask Mary Fee not to press amendments 59, 60 on the basis that I will consider ahead of stage 3 what might be possible in this space. If they are pressed, I would encourage members not to support them on the basis that I have outlined above. I am not convinced that this approach is helpful or workable, but I will work with what the committee decide. Convener, I move Amendment 35 and ask members to support Amendment 36 and 37. And I'd ask Mary Fee not to place Amendments 59 and 60. Thank you.
Thank you, Minister. Mary Fee to speak to Amendment 59 and the other amendments in the group. Mary.
Thank you, Convener. Amendment 59 would strengthen the quality of the content of the bill by ensuring that listed authorities meet the requirements regarding children who have one or more protected characteristic or are in a situation of vulnerability, ensuring that they have their rights respected, protected and fulfilled. And by making this a requirement for listed authorities, the bill would provide more protection for children in these groups, and it strengthens the obligation of the listed authorities to do all they can to ensure the rights of all children are respected, protected and fulfilled. Amendment 60 in my name would provide greater clarity to listed authorities when using the bill. It would ensure that listed authorities actively work to meet the requirements set out in my amendment, and children will be better protected when listed authorities act proactively in promoting complaints handling procedures, ensuring that children have access to independent advocacy services and ensuring that children have access to legal aid. And this will make the bill stronger as it sets out a more transparent approach to reporting. Thank you, Convener.
Thank you, Mary. No other member has indicated they wish to speak, so can I ask the Minister to wind up, please?
Thank you, Convener. I believe the Scottish Government amendments will ensure there's an effective reporting cycle which provides transparency for children and young people about the steps which listed public authorities plan to take to realise children's rights and the effectiveness of such steps which have been taken in the previous years. Public authorities are subject to many reporting obligations, and it's incumbent upon all of us to ensure that when we ask them to report, we do so in ways which they can deliver without placing overly prescriptive requirements on them, which can lead to tick box exercises. I think the balance which the bill strikes, as strengthened by the Scottish Government's amendment, is the correct one, but as I have indicated, I am happy to work with the committee decision, as we have done for the Children and Young People Scotland Act 2014. This will be supported by guidance for public authorities. Thank you.
Thank you, Minister. The question is that Amendment 35 be agreed to. Are we all agreed? Amendment 35 is agreed to. Call Amendment 36 in the name of the Cabinet Secretary, already debated with Amendment 35. Minister to move formally, please.
Moved.
Thank you. The question is that Amendment 36 be agreed to. Are we all agreed? We are agreed to Amendment 36. Call Amendment 37 in the name of the Cabinet Secretary, already debated with Amendment 35. Minister to move formally, please.
Moved.
Thank you. The question is that Amendment 37 be agreed to. Are we all agreed? We are agreed. I call Amendment 59 in the name of Mary Fee, already debated with Amendment 35. Mary Fee to move or not move, please.
Thank you, Convener. Given the very supportive comments that the Minister made in relation to my amendments, I am happy to work with the Minister ahead of stage 3, and I will not be pressing Amendment 59.
Thank you, Mary. Amendment 59 is not moved. I call Amendment 60 in the name of Mary Fee, already debated with Amendment 35. Mary Fee to move or not move?
Not moved.
Thank you. Amendment 60 is not moved. I call Amendment 49 in the name of Gillian Martin, already debated, with Amendment 47. Gillian Martin to move or not move?
Moved, convener.
Thank you. The question is that Amendment 49 be agreed to. Are we all agreed? We are agreed. The question is that Section 15 be agreed to. Are we all agreed? We are agreed. I call Amendment 3 in the name of Alison Harris, grouped with Amendment 4. Alison Harris to move Amendment 3 and speak to both amendments in the group, please. Alison.
Thank you, convener. I move these amendments in my name. Regular reporting and public scrutiny play an essential role in embedding children's rights in decision making. Accordingly, the duty on listed authorities to report every 3 years on the steps taken to ensure compliance with the UNCRC requirements has been widely welcomed. This builds upon and adds value to the existing reporting obligations on public authorities listed in the Children and Young People Scotland Act 2014. Given the impact that they have on children's experiences of their rights, Amendments 3 and 4 bring in the Scottish Prison Service and the Scottish Courts and Tribunal Service within the scope of this duty. Both these agencies have a leading role to play in implementing the UNCRC requirements, particularly in relation to the best interests of the child, Articles 3, children's relationships with their parents are child, Article 12, supporting children unable to live with their parents, Article 20, and youth justice, Article 40. Scottish Courts and Tribunal Service will need to undertake a number of steps to ensure that its existing processes align with the UNCRC requirements and progressively release the rights of children. For example, supporting children to engage with the courts, ensuring solicitors and advocates receiving adequate training, ensuring that all court and judiciary staff act compatibly with the UNCRC, supporting children to have their views taken into account in the adult criminal court when a parent or carer is being sentenced. Including the Scottish Courts and Tribunal Service within this duty would help to ensure scrutiny of this work and ensure that children and young people are involved and their views taken into account. Similarly, the Scottish Prison Service will need to undertake a number of steps to ensure that an existing process aligns with the UNCRC requirements and progressively realise the rights of children and their families. Children and families with a family member in prison experience stigma, keep the issue hidden and often do not seek support, even when it is available. Evidence show that children of prisoners are 3 times more likely to suffer from mental health problems than their peers, that they experience the separation as a bereavement, and that families often suffer financially as well as emotionally when a parental figure is removed from the home. These difficulties are exacerbated by the economic circumstances which many families experience before and after the prison sentence. Children are often not given information about parents being released from prison, which can be re-traumatising and disempowering. Including the Scottish Prison Service within the scope of the public body reporting duty will help to ensure that the best interests of children and families affected by parental imprisonment are at the heart of all planning and policy making. It will encourage a proactive approach to involving children and their families in discussions and ensuring that families affected by imprisonments are not forgotten. Thank you.
Thank you, Alison. Can I now call Mary Fee to speak to amendments in this group? Mary.
Thank you, convener. I would like to speak in support of both the amendments that have been lodged by Alison Harris today. I think they're both very significant and very important amendments. I have campaigned since I came into Parliament for the rights of children of offenders to be protected. And I know only too well that the children of offenders are often the most marginalised and vulnerable groups in our society, and it is really important that we do all we can to support and respect their rights. And I am delighted that Alison has lodged these amendments today, and I am happy to support them.
Thank you, Mary. No other member has indicated they wish to speak. Minister, can I come to you now, please?
Convener, I'm supportive of Amendment 4, but I'm of the view that Amendment 3 is unnecessary. The bill puts in place significant requirements for the Scottish Ministers to publish a children's rights scheme and to review the scheme and its operation every year. As part of this review process, Ministers were required to publish a report on an annual basis. Through these mechanisms, the Scottish Government will set out the steps it is taking or plans they have to comply with the duty in Section 6, and if Amendment 21 is passed, to give better effect and further effect of the rights of children. This requirement and the requirement to report annually will relate to all of the Scottish Ministers' functions, including those in relation to the prison service. Alongside Ministers' requirement to report on the Children's Rights Scheme, Sections 15 and 16 place reporting requirements on public authorities which are listed in Section 16, being authorities which have a significant role in the lives of children and young people. The steps taken by the Scottish Prison Service to fulfil the children's rights will be set out in the Children's Rights Scheme, because SPS is an executive agency of the Scottish Government, and this will be covered in reports on the Children's Rights Scheme under the requirement in Section 13. As such, Amendment 3 is not necessary, and I would ask Alison Harris not to press it. I'm supportive of Amendment 4, which will add the Scottish Courts and Tribunal Service to the list of public authorities required to report every 3 years under Section 15. The Scottish Courts and Tribunal Service are key partners in ensuring that our ambition for a justice system which has a children's right at its heart are delivered. I welcome the steps they are taking already in support of children's rights and their commitment to working with the Scottish Government in relation to implementation of the bill. Thank you.
Thank you, Minister. Alison Harris, wind up and press or withdraw Amendment 3, please, Alison.
Thank you. I would like to press Amendment 3, Convener.
Thank you. The question is that Amendment 3 be agreed to. Are we all agreed? If we're not agreed, there'll be a division by roll call. When members are called, please respond with yes, no, or abstain. Alex Cole-Hamilton.
Yes.
Mary Fee.
Yes.
Joe Fitzpatrick.
No.
Alison Harris.
Yes.
Gillian Martin.
No.
Alexander Stewart.
Yes.
My vote is no. Just take a second while clerks confirm. There were 4 for the amendment, 3 against the amendment. Amendment 3 is agreed to. I call Amendment 4 in the name of Alison Harris, already debated with Amendment 3. Alison Harris to move or not move, please.
Move.
Thank you. The question is that Amendment 4 be agreed to. Are we all agreed? We are agreed. The question is that Section 16 be agreed to. Are we all agreed? We are. The question is that Sections 17 to 20 be agreed. Are we all agreed? Committee is agreed. Call Amendment 38 in the name of the Cabinet Secretary, grouped with Amendments 41, 44 and 45. Minister to move Amendment 38 and speak to all amendments in the group, please.
Thank you, Convener. Amendment 38 is about the meaning of subordinate legislation in Section 21(3) of the bill. The amendment adjusts the definition so that it links more precisely to the description of primary legislation used in subparagraphs 1 and 2 of Section 21(5)(b). Amendment 41 will make it clearer that Ministers have discretion as to the manner in which reports under Section 23 are to be published, and not whether these reports should be published at all. Amendments 44 and 45 are technical amendments which are intended to improve and clarify the effect of Section 32(1)(a) and (b). They will bring into line the description of the legislation which might give rise to the need to make remedial regulations under Section 32 with that used in Section 19 of the Bill. Convener, I move Amendment 38.
Thank you, Minister. No other member has indicated they wish to speak. Are you content to move on, Minister? Yep. The question is that Amendment 38 be agreed to. Are we all agreed? We are. The question is that Section 21 be agreed to. Are we all agreed? Committee's agreed. I call Amendment 39 in the name of the Cabinet Secretary, already debated with Amendment 16. Minister, to move formally, please.
Move.
Thank you. The question is that Amendment 39 be agreed to. Are we all agreed? We are. I call Amendment 40 in the name of the Cabinet Secretary, already debated with Amendment 16. Minister, to move formally.
Moved.
Thank you. The question is that Amendment 40 be agreed to. Are we all agreed? We are agreed. The question is that Section 22 be agreed to. Are we agreed? We are. Call Amendment 41 in the name of the Cabinet Secretary, already debated with Amendment 38. Minister, to move formally, please.
Moved.
Thank you. The question is that Amendment 41 be agreed to. Are we all agreed? We are all agreed. I call Amendment 5 in the name of Alison Harris, already debated with Amendment 47. Alison Harris, to move or not move, please.
Not moved, Convener.
Amendment 5 is not moved. I call Amendment 50 in the name of Gillian Martin, already debated with Amendment 47. Gillian Martin, to move or not move, please.
Moved.
Thank you. The question is that Amendment 50 be agreed to. Are we all agreed? Committee agrees. Question is that Section 23 be agreed to. Are we all agreed? We are. Question is that Sections 24 to 26 be agreed to. Are we all agreed? We are. I call Amendment 42 in the name of the Cabinet Secretary, already debated with Amendment 16. Minister, to move formally, please.
Moved.
Thank you. The question is that Amendment 42 be agreed to. Are we all agreed? We are. I call Amendment 43 in the name of the Cabinet Secretary, already debated with Amendment 16. Minister, to move formally, please.
Moved.
Thank you. The question is that Amendment 43 be agreed to. Are we all agreed? We are. The question is that Section 27 be agreed to. Are we all agreed? We are agreed. The question is that Sections 28 to 31 be agreed. Are we all agreed? We are. I call Amendment 44 in the name of the Cabinet Secretary, already debated with Amendment 38. Minister, to move formally, please.
Moved.
Thank you, Minister. The question is that Amendment 44 be agreed to. Are we all agreed? We are agreed. I call Amendment 45 in the name of the Cabinet Secretary, already debated with Amendment 38. Minister, to move formally, please.
Moved.
Thank you. The question is that Amendment 45 be agreed to. Are we all agreed? We are. The question is that section 32 be agreed to. Are we all agreed? We are agreed. The question is that sections 33 and 34 be agreed to. Are we all agreed? Committee agrees. I call Amendment 61 in the name of Mary Fee, already debated with Amendment 20. Mary Fee, to move or not move, please.
Not moved.
Thank you. Amendment 61 is not moved. The question is that section 35 be agreed to. Are we all agreed? We are. The question is that sections 36 to 39 be agreed to. Are we all agreed? We are agreed. Call Amendment 46 in the name of the Cabinet Secretary, grouped with Amendment 1. I point out that Amendment 46 preempts Amendment 1, and if Amendment 46 is agreed to, I cannot call Amendment 1. Minister, to move Amendment 46 and speak to both amendments in the group, please.
Thank you,
Minister.
Convener. Thank you, Convener. Convener, as we reach the conclusion of this stage 2 process, I think it's important for us all to pause and reflect on what it is this legislation does. Scotland is now more than halfway through passing world-leading, groundbreaking legislation to incorporate the United Nations Convention on the Rights of the Child into domestic law. We should not lose sight of the scale of this achievement. Similarly, we should not lose sight of the fact that the real work starts when the bill is passed to ensure that we efficiently and effectively commence its measures. There's no point in passing legislation if we do not then get its implementation right. That is what will make the biggest difference for children and young people. I see the provisions in Part 3 of the bill as critical in this regard. Sections 11 and 12 require Scottish ministers to make a children's rights scheme and require us to publish a draft scheme and consult children and others. We will then be expected to make any changes before laying the scheme proposal before Parliament for a period of at least 28 days. We have already rejected Alexander Stewart's amendment giving a period of 2 years for producing the first such scheme on the basis that this government intends to do so before the Act commences. It therefore becomes challenging to see how we might achieve this within the 6 months Alec Cole-Hamilton's amendment is calling for in terms of commencement, and enable Parliament, indeed a newly elected Parliament, to play its rightful role in terms of scrutinising our proposals and allowing for Parliament to influence the design of the scheme. As the Deputy First Minister said in his evidence before committee, when a bill of this significance is taken forward, there is a balance to be struck between recognising the priority of an early commencement and the time needed for public authorities to prepare. The legal ramifications of this bill are of the highest order. Public authorities and all those undertaking functions of a public nature, including those undertaking functions pursuant to contracts and other arrangements, will be directly accountable through the courts for their actions. When this Parliament makes new law, it is important that fair notice is given to those that it affects. It is extremely positive that public authorities, from justice partners to local authorities and health boards, are supportive of this progressive step in the realisation of children's rights in Scotland. These public authorities and others are already working to ensure that children's rights are prioritised and that the necessary preparations for incorporation are undertaken. It is important to allow all public authorities and those undertaking functions of a public nature adequate time to undertake vital steps such as reviewing policy and practice and ensuring that guidance can be developed and deployed and that staff delivering services can receive training. As committee members will be aware, COSLA has written to every member of the Parliament highlighting their support for a 12-month implementation period to allow Scotland's bodies to develop the processes and the resources to support effective implementation. The bill will not just apply to children's services, but all public functions which engage children's rights. Crucially, adequate time is needed to ensure that the procedures and court rules required to support claims under the bill are in place on commencement. As I said, in relation to Amendment 4, the Scottish Courts and Tribunal Service are key partners in ensuring that our ambition for a justice system which has children's rights at its heart is delivered. In our engagement with them, they have told us that a 6-month implementation period would create significant operational difficulties for their organisation. As just one example, there's Amendment 18, which requires the court or tribunal to give the child an opportunity to give their views on the effectiveness of the relief, remedy or order that the court is considering. There will need to be consideration for the methods and support that will be available to the child to enable them to provide their views. An amendment to court rules will be required. Therefore, they support Amendment 46 for a 12-month commencement date in order to ensure that the relevant changes can be considered and implemented appropriately. We could apply a 6-month commencement period to this bill, but directing how this legislation moves forward into practice from the centre does not sit comfortably with me. It is not how I would choose to do that, not when we need all of the relevant authorities to help us to deliver the fundamental cultural shift we want this legislation to deliver for Scotland's children and young people. That said, there is more we can do to show that we not only acknowledge the concerns about a long lead-in time for commencement of the bill and its measures, but that we understand completely the impact the pandemic has had on many children and young people. As the Deputy First Minister made clear to the committee at stage 1, we are keen to avoid an extended pre-commencement period. Our Amendment 46, I think, achieves this and will ensure that momentum is maintained by committing us all to working to commence the legislation 1 year from royal assent. I therefore move Amendment 46.
Thank you, Minister. I call Alex Cole-Hamilton to speak to Amendment 1 and the other amendment in the group. Alex.
Thank you very much, Convener, and I take great pride in moving Amendment 1 in my name. As the Children's Commissioner for Scotland stated in the last line of his briefing to us, a year is a long wait. It is a long wait. And actually, the children of Scotland have been waiting far, far longer. Indeed, the UK first ratified the United Nations Convention on the Rights of the Child in 1991. When I was 14, I was a child myself when the UNCRC was ratified. I am now 43, and it is still not threaded through the laws of the land in the way it should be. We aren't world leading on this. There are many countries that have gone before us and have outstripped us in many other areas of children's rights. And Convener, the Minister states that we need to give authorities, public authorities and local authorities, time to get their systems in place, to get a line of sight to what this means for them. Well, they've had that time. They've had that time and then some, because public authorities have seen the direction of travel on children's rights and that they would be required to act compatibly with the UNCRC since 2011. I remind the committee of the majority SNP government's manifesto commitment in 2011 to bring forward a Rights of Children and Young People bill. It did that and then withdrew it and conflated it into the much broader Children and Young People Act of 2013. Or 2014 rather. That act had within it duties on public authorities to have regard and raise awareness of the United Nations Convention on the Rights of the Child. We're not teaching people new tricks with this. This is something that they have baked in and done so successfully. We should be very proud of the work of things like our Rights Respecting Schools, which recognise and educate our nation's children in the rights afforded to them under the articles of the UN Convention. As such, ministers, councils, public bodies have been working with the Convention on a day-to-day basis for the last 7 years. I mean, this government have a poor track record in slow-walking children's rights legislation. Let's not split hairs about this. You know, we are the committee that stewarded the age of criminal responsibility legislation through this Parliament 2 years ago. Now, for all the fact that you wouldn't ever see an 8-year-old prosecuted, right now, that is still our age of criminal responsibility. We are still one of the lowest in the world. You cannot lead the world on children's rights from the back of the pack. And I'm very concerned that if we, I mean, had we, I'm not sure that had I put my amendment in, the government would have produced a commencement date. And a year, I think, just gives it far too long to slide, when actually children's rights are being violated every single day, and they need an opportunity to find redress to that. They need an opportunity to find advocacy for that. And they need public authorities to build in processes to ensure that it just doesn't happen anymore. It shouldn't be an afterthought. It should be baked into the strategy and the development of all policies and procedures and new institutions that are created. My amendment is supported right across the children's sector with unanimity. And I think we need to listen to them. I understand that some of this might be difficult, but I think on children's rights, you have to throw your cap over the metaphorical wall. And I absolutely believe, I mean, the Children's Commissioner thought we could commence this from the date of royal assent. I accept that there are some logistical challenges in that. From all the work that I've done, and I have done extensive work on this, I think that speaking to stakeholders, both those who have to deliver this and those who have been calling it for generations, that this amendment strikes the right balance, and I move it in my name.
Thank you, Alex. A number of committee members are wishing to speak. I'll go to Gillian Martin first, to be followed by Joe Fitzpatrick, please.
Thank you, Convener. I feel that too often decisions affecting children are done without working with children and without engaging with them. And I have to say that we all in the committee want incorporation of the UNCRC as soon as possible, but we also want the incorporation of it to be effective. The Minister's points in relation to immediate effect, not allowing enough time to engage with children's and children's rights organisations on how the children's rights scheme should look and work. It's changed my mind on this. And we also voted today on a child-friendly complaint system, which we've agreed upon, and that needs time to be worked with children, and also to have our scrutiny as well in Parliament, so that that's right too. Alec Cole-Hamilton says that rights should be baked in already, but there may be public institutions where they're not baked in already, and if they aren't, then they need time in order to bake that in and to make sure that children have the rights that we all want. This can only happen with sort of working together with children, and I am really concerned that with an immediate commencement date, or the commencement date that Alec Cole-Hamilton proposes, that we won't have time for that to happen where those gaps are. And our scrutiny in this is important. Our engagement with children, the engagement of children across all public authorities on this is absolutely vital. And I note that other countries that have incorporated the UNCRC did not immediately commence. They did that vital work, and I want to see Scotland doing the same. Thank you, Convener.
Thank you, Gillian. Joe Fitzpatrick, to be followed by Mary Fee, please. Joe.
Thanks, Convener. I also want to speak in relation to Amendment 1. I appreciate I'm coming to this bill process later than colleagues, and probably I think it's appropriate to put on record from looking from the outside how impressed I've been with the level of engagement that the committee has managed to have with children and young people in spite of all the challenges. And that's where my challenge with the 6-month proposal is here, is how, and I don't know if Alex Cole-Hamilton gets a chance to come back in, how we would make sure within that timescale that those processes that the Parliament, that the organisations all need to take forward are informed by consultation with children and young people, particularly given that we're still in the middle of a pandemic. So I'm really concerned if we move at a pace that it is, I'm keen for this to come in place and be enacted as quickly as possible, but it needs to be done with children and not to children. So I don't know if others maybe want to respond to that. My preference, I think, at this stage would be, until we've answered those questions, I think Amendment 46 is the appropriate amendment, but I'm absolutely keen that at stage 3 we could come back and look at, how do we answer those questions to make sure that children and young people are absolutely central to the implementation of this bill when it becomes an act.
Thank you, Joe. Mary Fee, please.
Thank you, Convener. I'd like to speak in support of Amendment 1 in the name of Alex Cole-Hamilton. I fully support Amendment 1 and I support all of the comments in regards to commencement that Alex Cole-Hamilton has made. The point that he made specifically in relation to the age of criminal responsibility and commencement is a point that is very well made, and it's something that, in my view, should shame us all that we have passed legislation and there is no commencement date, that it's still not been enacted, and I do not want to see that happen to this piece of legislation. All of the stakeholders, all of them, and the organisations are prepared for this piece of legislation. They have been preparing for this bill for a long, long time. This is an ambitious bill. I agree that it's an ambitious bill. So let's be ambitious with commencement and have commencement 6 months from the date of royal assent. Thank you, Convener.
Thank you, Mary. Alec Cole-Hamilton wishes to come back in.
I'm very grateful to you bringing me back in, Convener. I actually find the remarks made by some members about not doing this to children but doing it with them is not just patronising, but it negates all of the work that has come from children and young people over years in respect of trying to embed rights-respecting processes, a children's rights-based framework into much of the strands of public life in this country. I would only direct you to the letter from the Scottish Youth Parliament, which almost is excoriating in the pressure it puts on this committee for early commencement. This is not something that children aren't aware of. They are watching this intently. They understand what's going to be required of them and their input into the processes that must be built around. But to say that we can't just take this decision against their wishes completely undermines the work that has been going into this from children and young people, their voices being heard at every stage, and their passion, their real passion, to see early commencement on this now or as soon as possible after royal assent, and not slow walking this legislation as this government is wanting to do with all aspects of children's rights.
Thank you, Alec. Alexander Stewart, please.
Thank you, Convener. I would like to support Amendment 1 in the name of Alex Cole-Hamilton today. We've already heard from Alex and other members about the support that this has across the sector, across the organisations and institutions that want to see this. And I am disappointed that the Minister has indicated that more time is required because, as we've already heard, organisations know about this process and have been gearing up to ensure. And when we have such a huge swell of opinion from the sector and from individuals and organisations who represent and support children, I firmly believe that this needs to be actioned sooner rather than later.
Thank you, Alexander. If I could invite the Minister to wind up now, please.
Thank you, Convener. The Scottish Government remains absolutely committed to ensuring that momentum continues and that the bill is commenced as soon as possible. It's in no one's interest, particularly those of children and young people, if we get this wrong. As a responsible government, it is incumbent upon me as Minister to ensure that I listen to those public authorities who are saying that they require time to get this right. Commencing a bill such as this within 1 year of royal assent would be one of the fastest approaches to commencement and implementation of legislation of this legal and constitutional significance. I believe that my amendment strikes an appropriate balance between ensuring momentum is not lost and giving public authorities time to prepare for their duties. I just don't believe it's credible to say that this government is dragging its heels. On the age of criminal responsibility, it was an exceptionally complicated piece of legislation. The changes that had the most material positive effects for children and young people have been prioritised since royal assent, and since March last year, the response to COVID-19 has impacted the availability of key colleagues right across the public sector and space in the legislative programme, frankly, in Westminster, not just in the Scottish Parliament, in order to make progress. We do, however, still expect that piece of legislation to be fully commenced this year. Part 1 of the Act has already I would expect it to be fully commenced this year. In terms of dragging our heels on this legislation, we are delivering this legislation this term of Parliament as promised. At a time when so much of our legislative programme has had to be dropped, this bill has been prioritised. And we are putting a date of commencement on the face of the bill. 1 year, as I have said, is hugely ambitious for this type of legislation. The Human Rights Act 1998 took 2 years to commence. And let's not forget that we are pioneers in this journey. We are the first country to incorporate in the UK. We are the first country, the first devolved legislature to directly incorporate in the world, I believe. I think we have a duty to get it right. I am pleased to have the support and commitment of our public authorities to the progression and realisation of children's rights across all public services that UNCRC incorporation will achieve. I don't think that they are dragging their heels either. COSLA, for example, recognised the need for a change in systems and practice, including training, development, audit, update of policies, development of child-friendly guidance, frameworks, materials, complaints processes, and so on, all of which requires meaningful engagement with children and young people as well as other stakeholders. All this at a time when local authorities are carrying a very heavy burden in dealing with the global pandemic. Now, whilst the pandemic has improved engagement for some, for example, children living in the Highlands, in the rural Highlands in my constituency may well find it easier to attend engagements which are held virtually rather than in person. But for some children and young people, engagement is harder. Some of the very children and young people who need this legislation the most will be excluded from the work required to implement it by a 6-month timetable. A 6-month commencement period at this moment in time with the public health restrictions we face will make it almost impossible to reach out to the digitally excluded children who need this legislation the most. It would not be my choice to direct this culture change from the centre. I would prefer to engage and work collaboratively, which inevitably takes time. Further, for a large part of the 6 months post-royal assent, as Gillian Martin indicated, Parliament will not be sitting, which will truncate further the opportunity for scrutiny of the scheme, for example, or scrutiny of the complaints procedure. And children and young people's engagement activities will fall in the summer period, which all of us know is not ideal in terms of engagement with young people. So I consider a commencement period of 1 year to be the responsible course of action. We have flexibility built in to commence sooner on some or all of this bill, if that proves possible. But we are ready and willing, however, to work with the timetable that Parliament decrees. Thank you.
Thank you, Minister. The question is that Amendment 46 be agreed to. Are we all agreed? We're not agreed. There'll be a division. By roll call, when members are called, please respond yes, no, or abstain. Alec Cole-Hamilton.
No.
Mary Fee.
No.
Joe Fitzpatrick.
Yes.
Alison Harris.
No.
Gillian Martin.
Yes.
Alexander Stewart.
No.
My vote is yes. We'll just take a second to have those votes confirmed. There were 3 for the amendment, 4 against the amendment, and no abstentions. The amendment is not agreed. Call Amendment 1 in the name of Alec Cole-Hamilton, already debated with Amendment 46. Alex, to move or not move, please.
Moved, convener.
Thank you. Question is that Amendment 1 be agreed to. Are we all agreed? We're not agreed. There'll be a division by roll call. Alex Cole-Hamilton.
Yes.
Mary Fee.
Yes.
Joe Fitzpatrick.
No.
Alison Harris.
Yes.
Gillian Martin.
No.
Alexander Stewart.
Yes.
My vote is no. We'll just take a second while clerks confirm. There were 4 votes for, 3 against, and no abstentions. Amendment 1 is agreed to. The question is that Section 40 be agreed to. Are we all agreed? We are agreed. The question is that Section 41 be agreed to. Are we all agreed? Committee is agreed. The question is that the long title be agreed to. Are we all agreed? We are agreed. And that ends Stage 2 consideration of the bill. The bill will now be reprinted as amended at Stage 2 and will be published on the website tomorrow morning. The Parliament has not yet determined when Stage 3 will be held. Members will be informed of that in due course, along with the deadline for lodging Stage 3 amendments. In the meantime, Stage 3 amendments can be lodged with the clerks in the legislation team. I thank the Minister and her officials for her attendance to them this morning. Our next committee meeting will be on Thursday, the 18th of February. And I now close this meeting.